Absolute outrage on social media, and understandably so, because of the woefully lenient prison sentences cast upon men that are convicted of historic offences against children. Jumping around words somewhat to avoid the YouTube algorithms flagging the video. I'm not a big news company, which is why they get away with it and I don't. I presume, at least. I don't know for certain, but I think so. So if you do appreciate my input as an individual, an independent barrister, please do subscribe to the channel. But these men have been convicted of offences from the late 1990s. Now, what people are outraged about is the fact that some of these sentences are horrendously lenient. 4 years, 6 months for the R word, 6 years, 6 months for two incidents, 3 years for another R word offence, 6 years, 6 months for another one. Now, many people clearly from the comments think that these are horrendously lenient for these kind of offences against children. Now, the first thing I would say is please don't blame the judge in each of these cases, because whilst that might be a convenient first thought to have, the judges have to follow the sentencing guidelines. But there is something that you, members of the public, can do about it. So bear with me while I explain that through this video. But the other reason that people are outraged by these sentences is that when you compare them with the likes of Lucy Connolly, who was sentenced to 2 years, 7 months for publishing written material to incite racial hatred. Obviously, people compare those two sentences and think, well, publishing something online, which was to incite racial hatred on the one hand, attracts 2 years and 7 months, whereas this chap got just 3 years for the R word of a child. Now, clearly people think that that is a horrendous comparison, but as I would say, don't jump to blame the judge, because they have to follow the sentencing guidelines, and if they don't follow the sentencing guidelines, then the sentence is open to appeal. The sentence is open to appeal, for example, if it's too excessive or too lenient, obviously by each party. The sentencing guidelines for the inciting racial hatred is on screen here. For a category 1A, which is the more serious, there's a starting point of 3 years and with a range from 2 to 6 years custody. And then right down at the bottom end in 2C, it's right down there with a low-level community order up to 1 year custody. Now, that's a reasonable range of punishment for these kind of offences, but then when you look at the very much more serious offence, this one here, that is engaging in or inciting someone to engage in, then we look at the potential sentences here. A category 1A right at the top end has a full range of 4 to 10. Now, the range is what will be considered, and obviously there's a maximum which is separate. You'll need to read these to fully understand it. But the maximum, triable only on indictment, only in the Crown Court, is a maximum of 14 years. But the range goes right down to a community order, which you may think is rather strange for this kind of offence, but depending on their involvement, etc., there's a whole range of different reasons that might be. But that is how these two offences can overlap. Now, a really serious offence in this case, I'm not saying that you should think that this is a really serious offence in this case. Obviously, I don't condone inciting material that incites any kind of hatred at all, much less inciting racial hatred, and these offences are properly prosecuted. You may disagree with that, and that's entirely down to you, but because of this overlap, people feel that these men being sentenced to these sort of custodial terms is insufficient. Now, what can you do about that if you really don't agree with that? Well, there is something you can do about that, because I've done this before, and I have noticed sentences being increased following, I'm not saying it's because of my report, but increased following a report that I've made, and I've seen that a few other people have made, and that is regarding this here, where you can ask for a Crown Court sentence to be reviewed. Anybody can do this. It doesn't have to be the prosecutor, it doesn't have to be a barrister, it doesn't have to be a lawyer even, or any kind of lawyer. You can ask, anyone can ask for a Crown Court sentence to be reviewed, because this is a public justice system. There are only certain types of offences that can be reviewed. such as these here. And as I say, I have filled these in before, and I have noticed that the sentence has been, in one case where I filed one of these requests, the sentence was doubled as a result of that. Not saying it's because of my report. I think a few people probably would have made this request because it was so lenient. So that sentence was doubled as a result of that. So how to get a sentence reviewed? If you fundamentally disagree with some of these sentences, such as these ones here, you can, if you get the details, submit a request on this website, and the Attorney General's office will review the request and decide whether or not to send it to the Court of Appeal, who then makes a decision about the sentence. You provide your name, your details, and then the details of the offender, the offence, etc., which Crown Court it was. And in this case here, it was at Bradford Crown Court. So if you were to feel that any sentence, not just these, but any sentence, if you felt that it was overly lenient, you can file this request to the Attorney General's office, and they will consider whether sending it to the Court of Appeal. Obviously, if more people send that request through, I don't think there's a rule about this, but it stands to reason that if more people send that request through, it is more likely that the Attorney General's office will send it to the Court of Appeal and review those sentences. Now, again, I have to somewhat defend the judges in a sense, not just because I'm a lawyer, but just because many people may not fully understand the way that this works. But as an individual, you will not have been in court, you will not have heard all the evidence, you won't have the full understanding of the case, and therefore the judge will apply all the mitigating circumstances as well as the aggravating factors of each individual and apply the sentencing guidelines accordingly and come up with that sentence. If the judge doesn't do that, then the judge's own sentencing is open to review. It's not just a case of judge passes sentence, that's it, and there's no more review of that. It can be appealed if it's excessive. So the individuals can appeal against sentence only. Obviously, you can appeal against conviction if there's a ground for it, but you can also appeal against sentence by itself. Likewise, the prosecutor can appeal directly if they feel that it's an unduly lenient sentence. And so in that sense, all I would say is that the judge follows the sentencing guidelines, and in many of these cases, they are within those bounds, within the sentencing guidelines categories. And if anything, it will be those that would need to be reviewed so that the judges have a different power to cast a sentence that you, as the general public, may feel more appropriate. This is a little bit like the comments that some of the judges made during the riot cases, the violent disorder cases. The judges were making comments that they were being charged as a much lower offence than they really ought to be if they wanted them to have a more severe sentence, because it really does tie the judge's hands to the sentencing guidelines as to what the judge can actually pass by way of sentence. But as I say, outrage on social media because a lot of people feel that these are unduly lenient sentences, but there is a way that you can get involved, have your say, and it's this website here. So I'll link this in the description below. You fill the form in, you put the details in, it goes off to the Attorney General's office. There's no guarantees, obviously, and they probably won't get back to you or anything like that, but you'll probably see it in the news if anything happens that the Court of Appeals reconsider the sentence and potentially increase that sentence. As I say, I've personally seen that happen before, and so the system does work to that extent. So I did this video because some people asked in the comments, what can you do about these kind of sentences? That's pretty much all you can do. If you're not involved in the case, you're not the prosecutor, obviously you can't appeal as such, but you can file these forms off. So I hope you found that useful. Please do like the video and subscribe if you like these independent inputs. And as always, thank you for watching.